Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville workers' compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. Welcome to episode 2 of Hurt at Work, a Kentucky workers' comp podcast. Today's topic is something that's going to be very important, especially if you've been injured. It's the top 5 things to do if you've been injured on the job. I'm here in the studio with attorney Scott Scheynost. He's a Louisville workers' compensation attorney who handles cases across the state of Kentucky and also in Indiana. Scott, welcome back for episode 2.
Happy to be here again.
Absolutely, my friend. So let's jump into this, because I think, when people are working, and the first thing they're really worried about is, okay, one, how do I get, who's going to pay for this? Who's going to, help me heal? But then again, what do I need to do and what are my rights here? So let's kind of walk through this. The first thing you always say is seek medical treatment.
Right. It sounds silly, but that's really what you need to do. If you're hurt, you need to get fixed. And you may have to go to the emergency room. You may have to go to an immediate care center. You need to get fixed before you worry about all the other stuff. You want to make sure the bleeding stops, the bones set, all that kind of stuff's taken care of. Now, in addition to seeking medical treatment, you need to know something. In Kentucky, you get to pick the doctor, and that's a huge thing. Other states, for instance, in Indiana, you don't get to pick the doctor. You've got to go to the company doctor. So if you get hurt, you need to get fixed. You need to get the medical treatment, but you also need to remember you don't have to go to the doctor the company sends you to. You get to pick the doctor that you want to see in Kentucky. Now, that's hugely important because generally your family doctor is going to have your best interests at heart. There's usually a reason why the company wants you to see a specific doctor. Those doctors tend to know who gets referred to them and why. They do things to make sure the companies continue to send them business. Your family doctor doesn't have that connection to the company.
No, you're not actually saying they may minimize the injury. Is that really what happens?
I'm not saying that, but there's an argument that probably could be made. In another life, I did work for the other side, the insurance companies and employers, and I was used to seeing professionals come in and say, we can lower your costs. We're more adept at dealing with work-related injuries than just a GP, a general practitioner. And think about how they're going to save costs. They're going to save costs by minimizing the amount of medical treatment you get. They're going to minimize the amount of medicine and tests you get. They're going to stretch out over time that treatment. And my typical experience has been that a family doctor will want you to get tests and medical treatment a lot faster than the company doctor they send you to.
Right, because they're worried about, the company obviously and the insurance carrier is worried about cost containment, whereas somebody who's working with you, your doctor, is going to be worried about getting you healed.
Correct. Yeah, that's the nail on the head right there. Remember, the company looks at a work-related injury more like a cost. It's an expense. It's just natural for the company to minimize that expense. So they're going to try to send you to people that are going to minimize that expense. And again, that may not be your best interest to go to their doctor. Now, in Kentucky, you get to pick the doctor. There's some things that prevent you from picking any doctor sometimes. If your company participates in what's called a managed care plan, that's like an HMO for work-related injuries. That is something that happens not frequently, but is out there you have to be aware of. If your company participates in a managed care plan, you still get to pick the doctor in that plan. They can't tell you which one to go to. And there has to be at least 2 doctors for every specialty for the plan to be approved. And it's pretty frequent. I've had this happen probably 3 times already this week. People came in and saw me, and they were told by their boss they had to go to a specific doctor. Well, that's not the law in Kentucky. And they will tell you that. The insurance company will let you know that. The supervisor will let you know that. But that's not the law. In Kentucky, you get to pick the doctor that you want to go to. And the best piece of free legal advice I can give you is to go to your family doctor or somebody you trust.
Yeah, start there at least. They may refer you to a specialist. Or, and I think a lot of times if something happens, you felt something pop or something, maybe you fell down or you got hit by something, and it's not until a day or 2 afterwards that you actually start to really feel that pain. And of course, the supervisor is going to be, oh no, just shake it off. Come on, no blood, no foul kind of thing. And a lot of people grew up with that mentality.
Most people are going to know though when they're hurting enough to have to see a doctor, and That's just a natural reaction. And if you think you need to see a doctor, you probably do, even if your employer doesn't want you to.
Right.
Now, if you do see a doctor, it's also important to let them know why you're there. For instance, if you hurt your back at work and you go see your family doctor and hadn't told your supervisor yet, you need to make sure you tell your family doctor that the injury occurred at work, because the doctor will create a medical record every time you see them, and they'll usually contain in that medical record history of why you're there. So if you did get hurt at work, it's important for you to give the doctor the correct history. Otherwise, if you don't tell them you got hurt at work, or if, you didn't think the work injury was that big a deal, and you mentioned something else, you slipped and fell, on the patio chasing the dog when you were letting it out. If they put that in the medical record, then that's what everybody's going to look at from that point forward as a cause of your injury. So it's important for you, number one, to see your doctor, and number two, you need to give them the correct medical history. And in every case, the insurance company and if you get to the point of administrative law judge, they will all look at the medical history you gave those doctors. And what you tell them about how you were injured is very important and will come up years down the road. Even if you get referred to 2 or 3 or 4 different specialists, the original history you gave about the injury to your family doctor, at the immediate care center, or the emergency room, is what everybody's going to be looking at as a cause of that injury. So if your history is not accurate, if your history doesn't reflect this work-related injury, you're going to have some significant problems.
Well, let me circle back around to something you said earlier about the insurance company really trying to minimize that cost exposure. The longer it goes from the point of injury to the point of medical treatment, it gives them a lot of wiggle room to say, well, this really didn't happen at work. Yeah. And suddenly now you're in a
lot of people
fight.
will work through the injuries, and a lot of guys are, we're trained to be tough guys, and, we don't complain. We get out there and do it. And you may got injured, say, on January 1st, but it might be February 6th, March 1st before you actually see a doctor about it. That doesn't help your case.
Right.
The insurance company, first of all, is going to question about whether or not you actually got hurt at work. When you've got that great big of length of delay in treatment. Secondly, they're going to say, well, if you did get hurt at work, it must not have been that bad if you waited 6 weeks to see a doctor about it. And you're going to have a lot of problems with the workers' compensation claim. Now, a lot of times we can solve these problems, but you're creating problems in the workers' compensation claim. And the more significant the injury, the more important it is to seek immediate medical treatment. Of course, if you're bleeding, you want to get that fixed. And, you need to see the doctor, get the stitches, that kind of stuff. But sometimes if you have what we call a repetitive motion injury, a lot of times I see this in back injuries where somebody pulls their back and they try to tough it out. Maybe your supervisor doesn't want to hear that you got a work-related injury. Maybe they say, suck it up, keep going, and you do what your supervisor says because you're a good employee. Well, they'll actually use that against you later on down the road. Yeah. Which brings us probably up to the next thing.
Well, and that's where I think is a great segue into, I guess step number 2 of the top 5 things to do if you've been injured on the job is you've got to notify your supervisor or notify management. And there's probably a form or something. I mean, you could just let them know, but the better you've documented this, the stronger your case may be.
Correct. Now, in Kentucky, the law is that you have to give notification to your employer, usually a supervisor or somebody in management, that you got hurt at work as soon as practical. So if you got cut and you're bleeding and your supervisor's standing there, you need to tell them right then. And that's sufficient notice in Kentucky if you tell your supervisor.
So verbal is, right?
Verbal in Kentucky, the law says written, but it's been upheld by the courts that verbal notice is sufficient. The problem comes up when your supervisor doesn't remember.
Yeah.
Or maybe, it's not your regular supervisor, or you're dealing with somebody else you're not used to dealing with, or maybe the supervisor doesn't want to report something because that increases the number of work-related injuries, which decreases the safety bonuses for the year. So, first of all, you've got to notify your supervisor. Once you've done that, then you comply with the statute. And you got to notify them as soon as possible. You may not know it's work-related. You may get hurt on January 1st, and you see a doctor 3 weeks later, and he says, oh, this is due to work. Well, then you got to give them notice. But in addition to notifying your supervisor, it doesn't hurt to make some kind of record about it.
Yeah.
Either if you've got a diary at home, make a note of it. If you text him and you got a copy of the text on your phone, that's great.
If you got a coworker, take
that's
him with
even
you.
better.
Yeah.
Make sure you stay friends with him and make sure he writes it down too.
Yeah.
But you got to. You know your situation a lot of times better than anybody else. If you think your supervisor is going to be wishy-washy on this, if you've had a hard time dealing with them before, then that's even more evidence that you need to create some kind of document that shows that you told your supervisor as soon as practical that you got hurt. Now, the best thing to do is to send them a written letter through certified mail. I've yet to see a specific client do that. I think I've done that for clients before. I don't think I've ever seen anybody do that, but the certified mail letter gives you good evidence of it. Generally, when you tell your supervisor about getting hurt at work, that's enough. It's the situations where the supervisor doesn't want to recognize it, the supervisor may have gotten fired. Then you've got to come up with some kind of alternate method of proving that occurred. Either you've got notes, you've got a text, you've got a friend that heard it, and if they create the documents at work, or they create what we call a FROI, first report of injury, then that's generally enough to satisfy everybody's notice requirements.
Keep a copy, or at least take a photo of it on your phone
if
or
you
something.
Can get it, yeah. If you know your boss has created that, then there's usually some kind of record that has happened, and that's usually enough. But the number one thing to remember is you got to notify them about it. And again, you may not realize it's work related until somebody tells you that later on. And when you're told, you got to let them know as soon as possible. And it has to be a supervisor, somebody in management. It can't be a fellow employee. And you got to make sure they understand it. That they recognize that you got hurt. And again, you probably need to be able to prove this later on. Either document it yourself, or have a friend talk about it, or if you feel confident your supervisor is going to back you up, if you know he or she is going to verify it, then you're probably going to be okay.
For those of you listening, let me step out of the list for just a second and clarify. My name is Jim Ray. I'm a non-attorney spokesperson. I'm just kind of co-hosting the episode with Scott. But Scott's a licensed attorney, both in Kentucky and Indiana. Scott, you want to tell me a little bit about your practice?
Sure. We do mainly workers' compensation, and today we're really talking about Kentucky workers' compensation claims more than Indiana. Our conversation is going to be mainly concerned with Kentucky. That's where most of the cases I handle are located. We've been doing this for over 30 years. They've changed the law about 6 times since I've been practicing. We handle cases that occur all over the state of Kentucky. In fact, if you get hurt in another state, we can probably help you. If it's a Kentucky workers' compensation claim, if you're a traveling salesman or you're a truck driver and you get hurt out of state, we can probably help you with that. But we've done this for a long time. We've handled cases all the way from the beginning to the end. We've got a lot of experience with this, and if you've got any questions about whether or not you've got a claim, feel free to give us a call. The number is 502-937-5287.
Right. Let me let you get a drink of coffee there, and I'll come back to that. Scott also has a website out there with just a ton of information on it. It's ScheynostLaw.com. That's SCHEYNOST. ScheynostLaw.com. Scott, you want to give us that phone number one more time for clarity?
Sure. It's 502-937-5287.
Alrighty. Well, let's jump back into our list then. We've got we're talking about the top 5 things to do if you've been injured on the job, and number 3 is to actually make sure the claim actually gets filed.
Right. There are statutes of limitation in Kentucky. That means there's a specific statute that says you have to file your claim within a certain amount of time. And in Kentucky, for a traumatic injury, is 2 years from the date of the injury, or 2 years from the last date you receive what are called temporary total disability benefits. That's money for being off work, whichever's later. So you've got 2 years from the date you're injured, or 2 years is the last time you got a check for being off work from the insurance carrier to file a claim. And that sounds like a long time, but it's really not. The longer you wait, generally the harder it is to prove your case, and the more difficult it is to get records and information together. So if you've got a significant claim, then you probably need to see somebody sooner as opposed to later.
Now, you mentioned, though, if it's a traumatic injury, but who's to say what's traumatic and not? It's better to go ahead and pick up the phone, get an attorney involved, or make sure you've got this thing underway. And you have ways, as the attorney representing the injured person, to make sure those claims are filed properly.
That's correct. There's different statute of limitations for a couple of different injuries. For instance, if you had what we call an occupational illness, if you had black lung or something like that, you've got different statute of limitations. If you were exposed to some kind of a disease like AIDS, you've got different statute of limitations. Right. But most people get hurt at work because of a traumatic injury. Something fell on you, you were picking up something, you were in a car accident, somebody ran into your forklift. Those are what I call traumatic injuries. That's the vast majority of those. And that's what I'm talking about today. That has the 2-year statute of limitations. If you've got a question about what kind of an injury, again, see somebody that knows what they're talking about, and we can sort out what the statute is. But the vast majority of claims are traumatic injuries. If you've got one of these other injuries, then you've got an interesting situation, and you've got a lot of other things that you probably need to talk to somebody about.
Yeah, well, and you used a legal term, the statute of limitations, and that basically, if you miss that by even a day, you're barred from bringing this claim, correct?
Yeah, after a certain amount of time, if you don't do anything, the claim goes away. And
regardless of the injury or the lingering effects of that injury.
Correct. If you don't preserve your claim by filing a claim or getting a settlement, for instance, in Kentucky, you get lifetime medical benefits. But if you don't do something to preserve that within this statute of limitations, then you lose that right. You've got lifetime medical benefits in Kentucky. You've got a right to reopen your claim if the condition gets worse. You've got a couple other rights in Kentucky, but you've got to do something to preserve all those rights. And even though they're paying for your medical expenses now, even though they're paying for money for being off work now, you still have to preserve all those rights. And a lot of insurance companies are not going to remind you that you've got 2 years. They're going to hope you forget about it. And you need to be proactive in this. If you've got any question about whether or not you got benefits, talk to somebody. Well, we can sort all this stuff out. But remember, the insurance company is not generally here to help you be better off. They're here to save money and make money for themselves. And normally, they're not going to tell you that you need to file a claim within a certain amount of time. So you need to be a little bit proactive on that.
Yeah. So let's go to item number 4. Make sure you're getting the right benefits. That's kind of interesting.
Yeah, there's all kinds of benefits that are available in workers' comp. The 2 main benefits are money for being off work, money for permanent disability, and then the other benefit is your medical treatment. And let's go back to the medical treatment again. It's always in your best interest to go to a doctor that you found that you think's got your best interest at heart. So, if that doctor thinks you need reasonable, necessary medical care, you get it. If the insurance company doesn't want to pay for surgery, that's their problem. They may want to fight it, but if the doctor thinks you need a surgery, if that surgery is reasonable, necessary, they have to pay for it. They may do things to try to prevent them from having to pay for that. They may send you to another doctor. They may send you to a specialist that they know is basically going to say that you're okay, you don't need the treatment before you go there. They'll pay that doctor $1,000, $2,000 to say that, and he'll say that. Surprise. But you need to make sure you get the right benefits. And just because your medical treatment's been denied, just because you're not getting the treatment that your doctor wants, doesn't mean that you're not entitled to it. So you need to make sure you get that medical treatment. Now, another thing about benefits, in Kentucky, when you're off work, you're supposed to get 2/3 of your average weekly wage. And there's a lot of limits on this, but essentially, the average weekly wage has to be computed by a very complex formula. We've got to look at your wages for the year before the injury. We've got to consider the money you made from overtime. We've got to consider money from concurrent wages. It's just not like your average, your hourly rate times 40 hours. There's a lot of things that come into that.
So a concurrent wage might be if I've got a second job.
I'm sorry, a second job.
Yeah,
concurrent wage is one of those legal terms. Yeah.
Right.
If you're working for somebody other than your employer, then you have what we call concurrent employment. You've got a second job. If your employer knows about that second job, then that's supposed to be included in your average weekly wage, which means the money you get is based on your average weekly wage. So if you can make that number higher, you're going to get more money, both for being off work and if you have a permanent problem. That's a very important factor in the formula, is how much money you're making. So it's a very complex formula. It's a lot of math involved in it. But we've got to look at your wages for the 52 weeks before each injury, per week, per hour, from all sources, the main job, the concurrent job, and we've got to figure out what your average weekly wage is. You divide your wages for the year before this into 4 quarters, and you get the best quarter. So a lot of times people have a quarter where they're doing a whole lot more work. I've had several people in the beverage industry that do a lot of work right around Christmas. Everybody's having parties and there's things going on. So they're getting a lot of overtime around Christmas. Other people might work in the summer a little bit more. Everybody's usually got some kind of a pattern where they work more than other times of the year. And you get the best quarter out of the year before the injury. Again, that may not be straight 40 hours times your hourly rate. So if you've got overtime, if you've got periods when you work more, if you're getting a bonus, all that stuff gets computed in here. And a lot of times what I see the employer doing, what I see the carrier doing, is they just do the easy math. They get $10 an hour. We multiply that by 40 hours a week, so they're making $400 an hour. That's what they figure up as their average weekly wage. Probably about 25 to 30% of the time, that's not correct, and we need to go back there and figure that out.
That makes sense. Now, the other thing that's out there is the possibility of filing a Social Security disability insurance claim at the same time.
Right. You can get other benefits in addition to workers' compensation from the same injury. For instance, if you're not able to work because of the injury or even for any other reason, you might be entitled to Social Security disability. You can get that into work. You can get that in addition to workers' compensation at the same time. And there's a complex formula about how we figure that out. But the thing you have to remember is there might be something else out there besides workers' comp.
Right.
You could be hurt in a car accident. And if you're hurt in a car accident, you might be able to get a third-party action against the person that caused the car accident. You might be able to recover PIP benefits if it's a Kentucky no-fault claim, in addition to the workers' comp injury. So if you got hurt because of a third party's negligence, for instance, you're operating a machine and somebody didn't have the guard on it they were supposed to, you might have a third-party claim against that. You can pursue that third-party claim in addition to the workers' compensation benefits. So there might be more benefits in it than just workers' compensation. And again, you need to talk to an attorney. Usually, the more serious the injury, the more benefits that are available. For instance, if you are hurt so bad you can't work, you may have a decent claim for Social Security disability insurance. If there is a big traumatic injury because of somebody's negligence at the plant, a third party, pressurized something that wasn't supposed to be pressurized, you may have an action against that third party.
Lockout, tag-out type issues.
Yeah, especially if it was a third party. You're limited to workers' compensation against your employer and your own employees, fellow employees. But if it's a third party, you might be able to pursue some of these other things. And that's when it gets real interesting. All these different benefits interplay with each other. They've got offsets and you've got repayments and things like that. That's stuff that you can worry about later on down the road. For right now, the big thing to remember is I may have something else available besides workers' comp.
In some of these programs or some of these, I guess, claims entitle you to back pay, or back benefits, depending on the situation, correct?
Right. Again, I'm not a SSDI, Social Security Disability Insurance attorney, but you can get back pay for certain periods. There's certain limits on that. If you had a car accident and you're not getting paid the right amount from workers' comp, you might be able to recover PIP benefits. You've got 2 years to do that. There's all kinds of things to look at if you have a serious accident. And again, the best thing is probably sit down and talk to an attorney and kind of walk through these things to see if there's something else available. It's not always there, but it doesn't hurt to call somebody to figure that out.
All right. And friends, if you're listening to this and it sounds complicated, it sounds complex, we've actually already arranged for 2 of Scott's colleagues to come in from some other firms, of people you work with and refer cases back and forth to on a regular basis. One is a personal injury attorney who does primarily car wrecks, and so you guys are going to have an upcoming episode or two where you talk specifically about the interplay between those 2 claims and how those work together. And then we're going to have another gentleman from right here in Louisville talk about Social Security disability claims, and again how those work together and how Scott works with this attorney to make sure that these claims can get filed properly to your benefit, so you maximize, I guess, the benefits that you deserve, really.
Right.
Scott, let's go ahead and go to the 5th item here in the top 5 things to do if you've been hurt on the job. And this is actually preserving your benefits. What does that mean?
Well, again, this ties back into a little bit before we were talking about making sure your claim is filed. In Kentucky, you have a right to lifetime benefits for work-related injury. Mainly these are medical benefits, but you also have a right to reopen your claim. Now, you've got to preserve those rights, which means you either have to file a settlement agreement or you have to file a formal claim and get a decision from an administrative law judge to do that. If you don't file something to preserve those rights within that statute of limitations, you lose it. So, you may have a serious injury that requires further medical treatment, further operations down the road, but if you have not been proactive and if you've not done something to preserve your benefits, you're going to lose that right.
So a handshake doesn't really work, doesn't cut it in this
No,
scenario.
An agreement to preserve your benefits has to be approved by an administrative law judge in Kentucky. So if you've got a verbal handshake, there might be some ways we can argue that preserves, but that would not be a fight I would want to pursue.
Right.
It's a specific document, a specific form that's supposed to be submitted to the Department of Workers' Claims. An administrative law judge is supposed to approve it. If that occurs, then you have probably preserved your rights. You can waive some of these benefits and you get money for them, but if you want to preserve those rights, you've got to have something in writing to do that. And if you don't do that, then you've waived them for the rest of your life. And insurance companies, again, aren't going to remind you that you need to do this. Insurance companies are not going to remind you it needs to be done within 2 years of certain dates.
But they'll be quick to remind you if you've missed the deadline.
Well, they will just ignore you.
Exactly.
They will not say anything else to you.
Yep.
They won't give you the time of day.
Yeah.
It's like you're a non-entity from that point.
Well, friends, if you're listening to this, that's one of the benefits of having someone like Scott Scheynost, representing you in your workers' comp claim. I mean, it's a matter of, it's complex. There's a lot of ins and outs. There's a lot a lot of things that you may not even be thinking about. But Scott's done this for a lot of years. He's good. He's got a great reputation. I've worked with a lot of attorneys throughout the state, and people know Scott. Scott is one of the go-to guys in Kentucky workers' comp, and it's one of those things that if you have a question, you need to get qualified answers, qualified advice, and Scott's happy to do that. Hey, Scott, if somebody, again, wants to get in touch with you, what phone numbers should they use?
Give us a call at 502-937-5287, and we also have a website. If you can spell my last name, you can find it. That's spelled Scheynost, That's Scheynost Law. I pronounce it Scheynost. I'm used to any other pronunciation, though. SCHEYNOSTLAW.com, and we've got information on how to contact us there. You can contact us through email, you can fax us, you can mail us something, but just give us a call. We're happy to talk to you.
And you're extremely responsive. I've heard that from other people, from other colleagues of yours who are working with you, that once they kind of hand it off to you, they don't really worry about it. You're good at what you do. Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's SCHEYNOST law.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.